Yeah, I mean, there isn't a reason why they can't answer that question. There shouldn't be any hiding of the ball, so they should be able to answer that question and provide that answer to you.
Okay. Yeah. Thanks.
Chetan, I think you can start admitting all.
I have one other question as well.
Yeah, sure.
Yeah. I was.
Rajesh, if you don't
Yeah.
mind, just hold on to it. Let me introduce attorney to everybody in the group.
Okay. No problem. Yeah.
Guys, we give us a minute or two, so we will get started. Thank you all for joining. Let me introduce our attorney for today, Justin Parsons. He represents Erickson Group from Virginia. Justin, thank you so much for joining us and accepting our request in such a short notice. We have a bunch of people with a lot of questions, with a lot of anxious. We need some answers. We're hoping to sail through this process. So before we get started, Justin, why don't you introduce yourself and then we can get started from there.
Yeah. So thanks for having me. I'll tell everyone a little bit about myself, and then I'll talk a little bit about the visa bulletin, so we can kind of have a background before we jump into the questions. So I'm a managing director at Erickson Immigration Group, EIG. So we're based in, we're headquartered here in Arlington, and then we have an office in San Francisco. We're about, I don't know, at this point, about 45 plus attorneys between Arlington and San Francisco, and then we also have a global presence around the world as well. We have employees in Singapore and London. So I've been practicing immigration law for 15 years, with the majority of that, on the business side. My specialty has always been, the perm and the immigrant visa side. So, I specialize in all these kind of complex issues surrounding getting green cards. So a little bit about the visa bulletin, the October visa bulletin. So I think one of the questions is, before we kind of dive into the questions, is, why did it jump so much? Kind of why we're here. So as a lot of you can probably remember, there were a lot of executive actions and proclamations earlier this year by the current administration. There were proclamations limiting the issuance of, green cards abroad for family members. There were other initiatives to limit green card issuance for employment-based visas. I think at some point the USCIS just stopped issuing green cards in the US for a period of a couple of months. So what you had was, statutorily, you have 140,000 immigrant visas that have to be used each year. And there's a similar number for family-based numbers as well. And what you saw is, because there was an abundance of unused visa numbers for fiscal year 2020, they rolled over to 2021. And normally, instead of having 140,000 visa numbers, we have 261,000 visa numbers for this fiscal year. So as you can imagine, that's kind of the reason why we saw the jump in the visa bulletin for essentially all the categories, and then especially for the backlogged countries as well. We saw EB2 jump a little bit. We saw EB3 jump a lot, at least in chart A. And then USCIS has announced that they're going to be using chart B for October. One of the things in the visa bulletin that they do mention is that the State Department thinks that there's going to be rapid progression in the next couple months. So what I've been telling our clients is, we've been working on gathering information and all the documents to file these applications, with the understanding that a lot of folks have been waiting over a decade to get their green card. So we're trying to get all of our applications out the door really as soon as possible, with the understanding that the visa bulletin may remain open for November, December. I think what the State Department's going to do and USCIS is going to do is take in all the applications, see how many people apply, and then probably adjust the visa bulletin accordingly, sometime in 2021, because they don't know, if there's an estimate of 130,000 people, for India EB2, they don't exactly know how many people are actually in line. Some of those people may have moved, companies to another entity. Some of those people may not be living in the U.S. at this point. So my guess is we're going to continue to see some advancement. They're going to give people a chance to apply for their I-45s, and then they're going to kind of adjust accordingly based upon the pure numbers that we see. So that's a little bit about myself, kind of where we're at in terms of the October visa bulletin. So I will turn it over to Kali, and he will, we have, I guess, about 16 questions, or probably a little more than that, to go through. So I think the format is, Kali, you're going to read these, and then I will attempt to answer. I will say, I think I probably have 99% of these questions answers to. I think there is a question on Schedule A workers. I can't guarantee that I can answer that question because I'm not a Schedule A expert. But everything else, I should be able to provide an answer to.
Thanks, Justin, for giving a good understanding about the current situation. Would you mind talking about recent immigration changes they're proposing? I know they're not into law yet. After 60 days, whatever they're proposing, their changes. Would you mind talking a little bit about them as well?
Yeah, so the DOL issued a new interim rule, which went into effect on Thursday, where the prevailing wage requirements for H-1Bs and then ultimately for perm have changed dramatically. So it's going to make it more difficult for employers to sponsor folks just in terms of the prevailing wage requirements. That went into effect on Thursday. We think that there's going to be, at least from a lot of the trade organizations that I work with, that there's going to be challenges in litigation, that the DOL rule violated the APA because there's no notice and comment period. They just kind of jammed it through as quickly as possible. So I would anticipate that there's going to be litigation surrounding that. But it's going to be a challenge for employers in terms of, finding adequate prevailing wages for folks on, transferring their H-1 or extending their H-1s. And then there was an H-1B rule, interim rule, that it will go into effect in 60 days on December 7th. That was released last week as well. Again, they're going to allow for 30-day comment period for this, so employers, individuals can submit comments to it. It really limits and tries to narrow the scope of who can qualify for an H-1B based upon the degree requirements. It eliminates some of the applicable evidence that you can submit based upon government data. And then there are restrictions on third-party placements and who qualifies as an employer or employee. So it's just a lot of, I would just say a lot, that's just trying to make it more difficult for extensions, new hires, wage requirements, et cetera. So we will see. I think that, one thing I could say is, like I said, there are, a lot of the organizations are threatening, litigation to prevent these two rules from going into effect. And then at the end of the day, it's up to, who wins the election in November. I think we could go in, two various directions. I think if the current administration wins again, I think we'll continue to see very stringent, limitations on legal immigration. I think we can probably see more of this. I think if the other side wins, at least based upon their platform, I think they're more likely to listen to businesses and to small businesses with regards to highly skilled legal immigration and just how important it is for the economy. And I can tell you that because I've worked with folks from the U.S. Chamber of Commerce and Compete America, and I do think that they would be a little more willing to listen to those trade organizations. So.
Thanks so much, Justin, for the details. So guys, we'll get started with the questions. We have, as Justin mentioned, we have around 15 to 20 questions already. And once we finish, can you all mute yourself, please? And then if time permits, we'll take the live questions as well. So I'm going to share my screen as well so that you can also read, see the question which I'm going to read. So the first question, Justin, is so my priority date is, I'm not going to read out the names of the persons who are sending these questions, just my priority date is July 2013 in EB2, and I have an approved I-140 with employer 1. Now I have an EB2 with employer 2 with pending approval, applied on July 27. Can I apply for a new EB3 140 in premium processing and file I-148 485 concurrently? What are the current risks for applying a new EB3 I-140 with the same firm?
Sure. So I'm going to assume here that the second EB2, the perm has been certified and this individual is just reapplying for the I-140 that was applied on July the 27th. So what you could do is you could, even before this new application is the EB2 is approved, you could reapply under EB3 with the second I-140, and then you could also file the I-45 concurrently. There aren't really any risks per se. You can't premium process the application. Well, you could try, but generally you can't premium process a downgrade because you're not filing the case with an original labor cert. You can only premium process if you're filing with an original labor cert at this point. So I guess to answer this question, assuming we're talking about a pending I-140 and not a pending perm, you could file the downgrade even before that EB2 I-140 is approved, along with the adjustment, without premium processing. And there, as we know, there's really no risk to that. So I would say that's the answer to that question.
A supplementary question to this, Justin. So a lot of people are curious to know how long they need to wait, especially to apply for the premium processing on I-140, because I think they have to wait for a receipt notice, right? So how long that could take? 2 weeks, a month, or any clue?
Yeah. So normally, how it works with I-140 premium processing is, so say you have the original perm application that was certified, or even since COVID, now they're not issuing the original perm application, they're issuing everything electronically. So generally, you could apply for premium processing with that first application. If you're doing a downgrade, so if you have a pending I-140, or if you had an approved I-140 and you want to downgrade that to EB3, you can't downgrade it, or you can't premium process the downgrade because they don't have the original perm application. So, but in general, guidelines when you submit the first application and you want to premium process it, you can either submit the premium processing concurrently, or you can wait and get the receipt and then try to submit it to premium processing after that. But just as a general rule, you can't premium process downgrades because you're not filing with the original labor cert.
how long that could take to receive a receipt notice for a when we file I-140 and 485 concurrently? Is it?
I mean, generally, I would say that the receipts come in about 2 to 3 weeks. I'm telling folks probably about 3 to 4 weeks, just because we're seeing delays with USCIS and then the Postal Service. So we're seeing, I think, receipts come in about 3 to 4 weeks after we file.
Thanks, Justin. So we'll jump on to the next question. So the question is, once my OPT is approved, I will have 90 unemployment days. My question is, if I don't get a full-time job, what are my options to maintain my student status legally? Can I work as a volunteer research assistant at a university, or can I work as an unpaid intern at a company?
Yeah, so it doesn't have to be paid, but you do have to have employment within the 90 days. So you could go work as a research assistant. I would say there are employment rules per state in terms of the types of positions that you can work in as unpaid. So I would say that it's kind of an employment law question, and it depends upon what state you're in. So you'd have to talk to the prospective employer, but you could definitely work on the OPT, maintain status, even if you aren't getting paid. Getting paid is not it's not a requirement to work and maintain status under OPT.
Jump on to the next question. I'm in EB2 India with October 2010 as a priority date, filing for I-485 based on filing date. My daughter is 19-year-old now and will be completing 21 in July 2022. She is on H4, valid until March 2022, in college currently, and got provisional admission into medical school to start from August 2022. If I file her I-485 also now, will she be protected under Child Status Protection Act? Can I apply for her F1 at an appropriate time after filing 485? How long I can wait before applying for her F1 based on the current processing times? What is the best course of action you recommend for me? Seems to be a detailed.
Yeah, so this one's a tough one. You just look at the visa bulletin, because that dictates the answer to this question. So in terms of I guess I'll take the Child Status Protection Act question first. So in order to lock this individual in under the CSPA, you have to be current under Chart A, and under Chart A, let's see, 10, 20. Chart A for India EB2 is showing September 1st, 2009. So you would have to be current under the requisite category under Chart A before your child turns 21. So in other words, if you file the adjustment at this point with your daughter, and at any given point in the next couple months, you become current under Chart A, then that will lock her in for purposes of the Child Status Protection Act. And then regardless of when the green card is issued, whether it's issued before she's 21 or after 21, she will still get the green card because she'll be locked in under the CSPA. So it all depends upon when the priority date is current under Chart A in the circumstance. In terms of switching over from H4 to F1, it's a little more complicated because there can be complications, switching from H4 to F1 when you have a pending adjustment. So that could cause complications in the future because it's it's a visa with non-immigrant intent consequences to it. So yeah, this one, the CSPA question is pretty easy, but the timing of the F1 is a little complicated. So I probably would say, you would need to work with your attorney on that in terms of the timing of the F1, the possible consequences of filing the H4 to F1 after you file the adjustment, because there's a possibility that the F1 would not be approved. So it's a little tricky, the F1 portion, Kali.
We'll go to the next one. So my employer is about to file adjustment of status or 485, and I got a new job with a joining date within 3 months. Question: should I file adjustment of status or not? If I file 485, will it get rejected? Will the decision on 485 can impact my future immigration requests, including my priority date?
Yeah. So what I would say to this one is that when you file the I-45 and your employer files, the requisite supporting evidence for the I-45 saying that there's a permanent job offer for you, they're making an attestation of the government that they're going to offer you this permanent position, this permanent job. So if you know at this point that you're not going to work in the job, or that you're going to file it and then switch jobs within 3 months, I would not encourage you to do that. I would encourage you to file the AOS if you're going to stay with the employer who's going to support you on this AOS application. But if you think that you're going to switch jobs in 3 months, I wouldn't file it. I think that could be considered fraud in some circumstances. So I would not consider filing an application for and with an employer that that you're not going to work for permanently when the green card is issued.
So Justin, I think I have a supplement question to this. So technically, it is that the person will be eligible to port his or her job after 180 days after filing 485, right? So
Yeah.
what if somebody got a pink slip within 180 days after filing 485? So can they still, because he is not voluntarily moving into other job, but his 485 is filed, but he don't have a job, can he still apply for 485J and then, if he finds a new job, and then can this 485 process continues with the old employer?
Yeah, so it's one thing where, on the day that you're filing, say, you're going to file the application on, October the 25th, the employer is going to offer you this permanent job. You're going to work in this permanent job once the green card becomes available. It's all about the intent when you file the application. And then, once the application is in, say something happens with the employer and you lose your job, then you could port the application to another employer. And you could utilize the AC-21 provisions. But it's all about the intent at the time that you're filing the application. So if you never intend upon working for that company and the company never intends on employing you, then that's considered fraud. But if you file the application, you intend upon working for the company, and at some point, as Callie said, you get a pink slip, then it's perfectly fine. The intent has changed, and you can port the case to another company, provided that it's the same or similar position. And then obviously they would have to do the I-45J to notify USCIS that you're changing jobs.
I think the reason I asked this question is because of the current COVID situation. Something like this could happen to a lot of employees doing the mass layoffs.
Yeah.
So somebody could get impacted because of it, and they don't want to go through the entire process again. So
yeah.
Thanks for answering that question. So the next question is, if we file I-485 when my son's H4 F1 change of status is pending, H4 to F1, does the USCIS approves his F1 or not? If not, what is the solution to keep him in legal status at the age of 21 plus? Right now he's 20.
Yeah. So it's very similar to the last question, which is, if you file a change of status from H4 to F1, and then when USCIS is adjudicating the F1, they see that you have a pending I-45. Yeah, there's a possibility, because an F1 is a non-dual intent visa, that they would not approve the change of status. And that's something that we addressed on a couple questions ago. So there is always that risk. It's possible that USCIS doesn't catch it and still approves it, but there's I would say a likelihood that they see that you have a pending I-45 and they don't approve the change of status in light of that.
The next one is it possible for him to file 485 separately as my derivative after his F1 get approved? If possible, what are the required conditions? Like
Yeah,
filing?
so assuming that you have an approved F1 and assuming that the priority date is still current or chart B is utilized, you could still apply for an I-45 as a derivative for him at that point. But again, I think the main thing to highlight here is that there could be a risk if you file, the H4 to F1. It takes, 7 months to adjudicate the F1, and when they're reviewing the application, they see that you filed an I-45 for him. That could be a reason to deny the application. And of course, if you do it after you get the F1 in terms of the AOS, I think you should be fine there. But it's about the timing of making sure that you'd file the AOS after he would have his F1.
Jump on the next one. I have a slightly different question than downgrade. I have invested in a rental property and have received rental income in 2019 and incurred expenses which are filed in 2019 taxes. I was passively involved as most of repairs are handled by a handyman for which I have bills as proof. During 485 process, will there be a problem? If so, what can I do to fix it? It seems to be a slightly different question.
Yeah, I get this question all the time. Passive investments such as rental property, it's not considered work, so it's perfectly acceptable for purposes of being on an H-1B or on a TN or an L. I have a lot of clients who do this. Even if it's disclosed on the 2019 taxes, it's not going to cause any sort of issue on the I-944. What we're advising a lot of our clients in terms of the I-944 is, USCIS is really going to look at your taxes, your credit report, and then your income. And as long as I think the standard is 250, percentage points over the poverty guidelines, we are not seeing any sort of issues on the I-944. So yeah, we're just generally advising folks not to get too bogged down in the assets and liabilities on the portion of the I-944. It's a very long and convoluted and complicated process, and as long as you're making as long as you have a high salary and a good credit score, the I-944 portion is going to go through and get approved.
The next question is, once we get EAD after filing 485, can we do any kind of jobs and can we start our own business too?
Yeah. So the key thing to think about with the EAD is once you start working on the EAD, so say you're working as a software engineer, you get the EAD, and then you want to start your own business. If you start working on the EAD without doing any sort of additional part-time H-1B, there can be violations to the H-1B status. You could then just continue, obviously, to work on the EAD for your current employer, but yeah, any sort of external employment that's outside of the scope of your current H-1B without doing an additional part-time H-1B can violate the terms of your H-1B status. So you could technically, start your own business or go work at Starbucks or, take a part-time job, but there can be consequences to the underlying H-1B if you're still maintaining that.
three questions here. We'll see. If I downgrade from EB2 to EB3, do I lose my EB2 status, or would it still be valid since I have an approved I-140? The reason I'm asking was that if I downgrade to EB3, but the final action dates move faster in EB2 in few months, can we just file another AOS application using my EB2, or should we file another I-140 application again? I believe it's a very common question, I think, these days.
Yeah. So it's all about how your attorney ultimately files the downgrade. So we have been filing downgrades for folks probably for the past 6 years, ever since there's been movement, on especially for China with EB3 becoming faster. So we've done a lot of downgrades for folks from China. When we file our downgrades, we file our applications as new petitions. So they have the EB2, we file a downgrade EB3 as a new petition, not as an amended I-140. And then they essentially have these two applications that are both approved. And if EB3 becomes current faster, they get their green card on that. If EB2 jumps ahead, we will ask USCIS to then attach the EB2 to the pending I-45, and then they would have to try to adjust on the EB2. I guess you technically could. We don't, just as a general practice, I don't recommend filing a second AOS. There are some circumstances where you could file a second AOS. I generally find that it gums up the system a little bit in terms of your own process. But if you file the downgrade with the AOS and then the EB2 becomes current faster, we're recommending that folks, that they would contact us and we would file some sort of request asking USCIS to apply the EB2 to the I-45. We're generally saying that could take anywhere from 3 to 6 months. And we would not recommend a second I-45 filing. And of course, this is all dependent upon, how your attorney is doing it, whether they're filing, the EB3 as an amendment, because then if they do, then you lose your EB2. So I would say it's dependent upon kind of the strategy of your attorney. And I know that there's a bit of controversy right now in terms of how to file the I-140s, whether you file them as new petitions or whether you file them as amendments. Like I said, we have filed them as new petitions for about 6 years now. We've never gotten any application rejected. So it's just, I guess, something to think about.
Respecting everyone's time and other questions in queue, I would probably get back to the other questions. So I want to make sure everybody gets at least one question answered. So I will go to the next question. So the next question is, I have an approved I-140 with company A, priority date May 2014. Right now I'm in India working for company B. For October visa bulletin, can I go for I-485 consular processing if company A provides me with 485 supplement J?
No, the only way you could file is you could proceed with the application through company A through consular processing. But in order to then file either an adjustment or go through consular processing with company B, you would have to have an approved I-140 with them. The supplement J is only applicable, if you have a pending I-45 with another company. So you've filed your I-140 and I-45 with a previous company, and then the supplement J works to port that to the new company. But you would need the I-140 with company B.
Can he not apply, like if the old company wants to continue with the process as for a future job, can he not do it?
Oh, for company A?
Yeah.
Yeah, you could do that. Keep in mind that all these applications are for future positions. So if company A wants to proceed with, consular processing with that position, you could absolutely do that. You would just have to demonstrate when you show up at the embassy that there is a future position available for you, and there would likely be some additional scrutiny to make sure that it's a valid job offer.
Provided company A would like to proceed with that application.
Yeah. You could do that.
The next question. If I apply 485 when my son's, I think it's the same question.
Yeah.
I'll jump on to the second question and see if I've covered this. If I file 485 for my family, excluding my son right now, is it possible to include him after he got his F1 approval?
Yeah, we talked about this before.
Yeah,
it's possible to do that once you have the F1 to file for the adjustment, provided that the priority date is current, the visa number, either Chart A or Chart B. So it's really dependent upon that. But yeah, a lot of these CSPA questions can be a little tricky. So I advise you to consult with your attorney about this, because they can be on the more complex end of the spectrum.
Next question is, my priority date is June 2nd, 2011 in EB2, and I'm planning to downgrade to EB3 to apply for EAD. I believe we can interfile in EB2 if EB2 dates got current. So, can I do this even if my filing dates are current? I think you have answered this question.
Yeah, you can, provided that the EB3 is filed as a new petition and not an amendment. If the EB2 becomes current, you can have your attorney contact USCIS and link up the EB2 to the adjustment. It's not something that is easy and takes a month. It probably takes 3 to 6 months, depending upon, ultimately who's in charge. We used to be able to do it back in the day probably within a month, but the bureaucracies at USCIS is making it a little more difficult than it used to be.
Question is, I myself and family have some missing I-94s, not the latest one, but the old ones. But do have visas and old passport? Is it okay to file I-485 with this?
Yeah.
Don't they ask for only latest I-94?
So generally what I advise folks in terms of if they're missing passports or old visas, to just file everything, file with what you have. It's possible that you're going to get an RFE requesting, old I-797s to prove that you were in valid visa status. But yeah, I have a lot of folks, as long as you have the I-94, whether it's the I-797 or the electronic I-94 showing that you're in valid status now, even if you're missing, a lot of folks have been here for 15 years, and maybe they lost a passport and replaced one, or maybe they're on their third passport while they're in the US and they don't have a copy. We can still file. I would say that the important things are obviously the current I-94, and then just to demonstrate that the entire time that you've been here, you've been in valid visa status.
This is a question you probably were mentioning about. My priority date is June 2011 in EB2, and I'm a physical therapist, Schedule A worker. Can I file downgrade to EB3 and I-485 by myself, as all the attorneys I've contacted are not able to due to the limited time? My employer is supporting. Should I apply for amendments or as a new I-140 based on previous labor condition approval? I have paid Social Security taxes for 40 quarters. Do I still need 944?
Yeah, Callie, your sound cut out a little bit.
Sorry about it.
But I can kind of go through this. So this is something we had talked about before, which is, should I apply for an amendment as a new I-140, or whether it's a new I-140? I said in my opening that I'm not the expert on Schedule A workers. So I'm going to decline from commenting on that, because I don't want to give you incorrect information about Schedule A workers. But what I would say is, again, it goes back to how you file the I-140, whether you file it as, the downgrade as an amendment. If you file it as an amendment, then it takes over the EB2, and then you can't use the EB2 at a later point. If you file it as a new I-140, the difference is just checking the box differently. There's a box for, filing as a professional versus an amendment. That's all that it is in terms of how you file it. If you file it as a new I-140, you can always take advantage of the EB2 later if it becomes current. And then in terms of the I-944, you have to submit it with all I-485s at this point. This is something, again, that was implemented within the past year. There was a brief stay on I-944s, but they're back essentially. Even if you've paid Social Security for 40 quarters, you still need to do the I-944. So you need to submit your tax transcripts, a credit score, and then evidence of either your current employment, which has to be over a certain threshold, or you can also add in liabilities depending upon what your salary is. But you always have to do the I-944 if you're submitting it, the adjustment of status.
Thanks, sir. So we go to the next question. What is the process to go back to EB2 after downgrading to EB3? Do we need to file firm letter again? You have answered this, but maybe.
Hey, Callie, your sound is cutting out again.
Oh, I'm sorry. So it says, what is the process to go back to EB2 after downgrading to EB3? Do we need to file firm labor again?
Yeah, so we talked about this, that it's a request for USCIS to link up petitions again, provided that the EB3 is filed as a new petition. So, your attorney would just contact USCIS and ask them to apply the I-485 to the EB2 I-140. So a perm is not needed.
Please post your questions in the messenger and in the messages. Once I finishes all the questions we have received in advance, we will try to attend as many as we can today. So the next question is, my priority date is EB2 July with company July. They didn't mention the year. So with company A, applied 765 and 485 as a derivative applicant with EB3 2014. Do I need to file adjustment of status again in EB3 to downgrade with the derivative applicant as primary in EB3 to make use of my priority date from EB2? If I use the EAD from derivative filing in EB3, in future, do I need to stick to EB3 category or just interfiling to switch the applicants with the earliest date work?
Yeah.
Too much complex.
Yeah, so if you want to file as the principal to downgrade to EB3, you would need to file the EB3 along with the adjustment of status if you want to have your own separate petition. We've got a lot of spouses who, maybe the husband applied initially and the wife applied as a derivative, and now the wife is current. The one thing that I would say just to keep in mind is sometimes there can be, job loss. So what we're seeing with a lot of, spouses is, maybe they're filing independently. So one spouse is filing, the other spouse is filing as well. So if you're kind of worried about, I guess, overall security and having, AOSs, I think, the thing to keep in mind is that if you just remain a derivative, and then something happens to the prior principal's case, there could be an issue with that. So you may want to think about filing the downgrade additionally and using that priority date from EB2 just as an additional safety net. Having the additional AOS may not be too much of an issue because one is for a principal and one is for a derivative, so it should not be too much of an issue. And then the EED question. I used the EED from derivative EB3. Future, do I need to stick to EB3 category or just interfiling to switch applicants with the earliest work date? Yeah. The answer would be you could switch to EB2 in the future if it jumps forward. You wouldn't have to just stick with EB3.
Back to one of those three questions we had pulled on because we've answered the first question. Are there any chances of final action dates becoming current? My priority date is April 2011, faster in EB3 versus EB2, considering the number of I-140 applications filed approved in EB2 are far more than EB3 between 2010 and April 2011.
Sure.
Some speculation.
So that's what I would, tell a lot of folks, is that just based upon the data that's out there in terms of, who's in the queue, I think that there are a vast amount, more folks who are in the EB2 queue than the EB3 queue. So what I'm telling all my clients is, if you have a priority date, 2010, 2011, I think that there's a decent chance that, maybe some of the queue is cleared out this year, given the excess of visa numbers, the additional 120,000 visa numbers. So I think that if you have a chance to downgrade, there is probably a significant advantage to downgrading to EB3 and possibly, getting a visa number. So I think if it were me, I would downgrade, because I think, the queue would be shorter for EB3.
The next question, that is, my wife and I have approved I-140 in EB2. Her priority date is December 2020 and mine is April 2011. If we file independently, me downgrading to EB3 and my wife in EB2, can I add myself to my wife's application or add her later, vice versa, to my pending I-485 at a later stage if the application is still pending?
Yeah, you could. We're talking about a 9-year difference. So my guess is you're going to get your green card way before, your priority date is going to become current way before hers. So something to consider.
I have a few questions, Justin. If you have a few more minutes, I can ask those. Let me know how your time permits. Justin, if your time permits, if you have 10 more minutes, I can ask for a few more questions left.
Yeah, sure.
Thank you. Can I file 485? This is from one of the live applicants who are in the call. Can I file the 485 with a new office address for my employer, but my 140 has an old address of employer? I'm with the same employer, but the just location has been changed.
Yeah, provided that it's within the same MSA, the same metropolitan statistical area. So in other words, if you file the I-140, for Chicago, and now you work in New York, that would not be considered the same MSA. But if the office just moved within the same, MSA, you could still file the I-140, the adjustment. But just bear in mind that the office location, which has changed, must be in the same, MSA. It's a pretty common question.
The next question is, my 797 is valid till 3/20/23. Visa stamping is till March 23. I-94 validity was only for September 1st, 2020 due to the passport expiration. Please let me know what are the options to renew the I-94.
Sure. So this one, I don't know if I can answer fully, just because we're kind of missing a fact. It's all about kind of the last action rule here in terms of when was the last time that you entered. So if the I-797 was approved after the last time you entered, but the I-94 was shortened because of the passport, then you're fine. But if the entry with the shortened I-94 was after the I-797, then you would have to make a nunc-pro-tunc request with USCIS. So you'd have to file an extension. So we're kind of missing a major fact, but it's all about kind of which occurred last, whether it was the I-797 approval or the entry. If the entry was the last of those two steps, you need to speak to your attorney ASAP about this.
Me and my wife have a EB2 I-140 from different employers. One is Jan 2014, the other is December 2014. Both employers are ready to downgrade, but my wife's employer says he got some denials last year and is cautioning us. So can we do concurrent processing with both employers just to be safe?
Yeah, you could. Again, as I said before, I don't like people filing multiple applications at the same time, but when it's, you know, your spouse is going to file one and you want to file as a derivative and vice versa, I think it's acceptable to do.
My I-94 travel record is not shown on website. Can I write 797 with I-94 record number in 485 application?
Yeah, I mean, I would call CBP or have your attorneys call CBP to inquire as to why it's not showing up. And then ultimately, at the end of the day, whether it's the I-797 I-94 or whether it's the last entry I-94, you would just indicate that on the adjustment of status application. But I would call CBP to try to get it corrected. You don't want to have that missing for a long period of time.
If I downgrade to EB3 and use the benefit of EAD and advance payroll, at a later point, if EB2 becomes current for my priority date, will I be able to switch or interfile from my 485 to EB2?
Yeah, we covered that before. Even if you start using the EAD and the advance parole, if EB2 jumps ahead in the future, you can always try to request that the EB2 is applied to the adjustment, and that doesn't preclude you from, just the fact that you use the EAD and the AP doesn't mean that you can't do that. So.
How do I invoke CSPA? Should I need to file application to invoke them or just writing a cover letter for them? What is your prediction for filing date for the priority date, 5th October 2011?
Yeah, so how you would invoke it is, you file your application under Chart B. Once the priority date becomes current under Chart A, it automatically invokes the CSPA. There isn't anything that you need to do. They would just continue, ultimately, when USCIS is about to issue the green card, as of right now, they would call you in for an interview along with your dependents. At that point, you would point out in the interview that the CSPA applies, and then the green card would be issued. In terms of prediction for October 5th, 2011, like I said, I think pursuant to the visa bulletin, there's going to be rapid progression this year. So probably in about 9 days, the November visa bulletin will come out, and we'll figure out whether it's going to be open for, another month. But pursuant to their comment, to their footnote, I would anticipate some additional movement.
I'm on EAD. My priority date is November 9 EB2. 2 more months movement required to become current. Do you think I should downgrade or just wait?
Yeah, that's a pretty good priority date. I would probably take a look at the visa bulletin for November, but you're probably better off just waiting, I think, given how close you are under EB2.
I'm sorry, I'm rushing because I just wanted to answer as many questions possible before we end up the call. If ETA document is missing with me and my attorney, and attorney provided only draft copy of ETA but did not provide the approved document, what is the procedure to apply for duplicate document from DO?
Yeah, so there is a way to file the application still. There's a box that you check on the form on the I-140 to request the duplicate copy of the perm. So even if there's a missing page, sometimes it happens. It's not the end of the world. You can still file the application. But yeah, it's just a box that you check on the I-140 itself.
My former employer, I believe employer is missing here, filed my first perm and denied in 2003 and filed second perm and got approved. Is there a way we can port to the first denied perm now?
Unfortunately, there isn't.
After getting the 485 filed and getting EAD in hand, can spouse work on EAD and primary H-1B applicant remain working on H-1?
Yeah. The spouse can work on the ED, like the H-4 ED, as long as, we advise our clients that you continue, even though you have the ED, that you continue to maintain your H-1B status.
My priority date in EB2 is Jan 2014 and haven't changed an employer since. My employer is willing to do EB3, 140 and 485 concurrent. Are there any risks of rejection if they file as new petition versus amended?
Yeah, so I think that we've talked a little bit about there's a lot of rumors going on. I've had other practitioners reach out, and there's folks who are saying that they've received rejections when they filed as new I-140s. I mean, we've been filing downgrades for 6 years, and I've never received a rejection filing as a new I-140. And we filed probably between, I don't know, 600 and 700 downgrades over the past, 6 years. So I don't know if it's just because there's practitioners who haven't done this before, but there's a bit of a rumor out there, and I recommend filing as a new petition. Couple more questions. I think we're coming to an end. My former employer filed my first form in EB2 and denied in oh, okay, sorry, this is again a repetitive question. Yeah.
Should I need to fill I-944 for all dependents, including minor child?
Yeah, on the I-944, you need to include dependents because they need to see the size of the household. That is a requirement.
The next question is about aging out, so I'll probably ask this question. We filed 485 for my 19-year-old and decide to apply for F1 later. Can you take back 485 before applying to F1 to avoid issues with F1 approval? And how long will the process likely to take back high 485?
Yeah, Callie, this is one we've kind of discussed before.
Yeah. Sure, I will probably jump on the next one. I think I just have 1 or 2 more questions. What is the advantage of having H-1B after getting EAD? Do I get more questions in EAD while port of entry, or any other reason why should I maintain H-1B?
Yeah, so it's the additional, safety of having the H-1 in the event that the I-45 is denied, then you have a visa to go back on. It's really the kind of the additional, safety precautions for having the underlying visa in addition to the ED.
My wife change of status changed from H-1B to H-4 EAD featured, and later on decided to continue on H-1B, requested USCIS to cancel approved H-4 EAD and remain on H-1B, still didn't receive confirmation. Now, is she on H-1B or H-4 EAD?
So if the H-4 was approved, then she'd be in H-4 status. So it's really what happened later in time. So she should really follow up with USCIS to make sure that the H-4 was withdrawn, because if they continue to process the H-4 and they approved it, then she would be in H-4 status at this point. So it's something she would have to follow up with USCIS on.
Sorry guys, I think we cannot take more questions because it's we've already close to 1 hour. So I just have just in one question from a couple of folks asking me offline about the processing times of EAD, because everyone are aware that H-4 EADs have been taking like more than 8 months now. So
Yep.
Most of us are worried that this 485 EAD also could take 6 to 8 months, or is it possible? Is there a maximum limit before which they have to approve? Or what is their guess?
Yeah, so we're telling folks probably 5 to 7 months. Maybe that's a bit optimistic at this point because there's going to be a lot of ED applications, obviously. USCIS has, as a part of the funding bill that went in, I think it was 2 weeks ago, they approved USCIS to start premium processing ED applications. What we're hearing is it's possible that it's going to go into effect in the next month or two. I think the fee for the processing, I believe it's like $2,500, and it could be up to 30 days, but there will be that additional option if folks want to, try to premium process their EEDs. But yeah, under normal processing, we're telling folks 5 to 7 months, with the understanding that, it could be longer, just depending upon how many applications that USCIS gets.
Thank you, Justin. Thank you so much for answering patiently all our questions today, and appreciate giving us time on a holiday on Sunday. Jagan, from just folks who are in the call but who don't know, the call is being handled by TACO from Columbus area. TACO President Jagan Garu, can you just give a thank you note to Justin? And for all who want to know or who want to research about Justin, he's Managing Director, Erickson Immigration Group from Virginia area. So you can probably search his information on Google and send an email to that company if you have any additional questions. Jagan, take it over.
Thank you, Eric, Jason, for joining us and sharing your valuable information to our community, TACO. And I really appreciate your time. I'm sorry we could not take all the questions. Still, they are coming. People are trying to join. That's a good. Hopefully, we can try to do it one more future. And thank you very much, team, for supporting it. Thank you, Jason.
Thank you.
Thanks, guys.